All right. They're hot. So far. All right, we can call a meeting to order.
11:06.
Let us start pledge of allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all for coming. Clerk Hearn, could we do a roll call, please?
Sure. President Hobbs.
Here.
Supervisor Bertrand.
Here.
Clerk Pern here. And special guest attorney Michael Bila here.
I'm going to change a couple of things in here to have it hopefully flow better. So I'll make a motion that we then adopt the agenda that way. So I called this meeting and invited the township legal firm, Mr. Bila, on retainer, to attend. As far as the agenda, I'd like to move the board comments to after this agenda item number 1 is the purpose of the meeting. I'd like to move the board comments till after that. Any other changes from the board that you think should happen there?
Yeah.
Okay, then I'm going to make a motion to approve amending the minutes as stated with the board comments coming after number 1 on the agenda. Do I have a second?
Second.
Okay, any further discussion from the board? Okay, hearing none, all those in favor of that amendment to the agenda signify by saying aye.
Aye.
Aye. Pose the same. Okay, that motion carries. Okay, so that would bring us to the agenda. Item number 1, I just wanted to read this for the public and for the video. The purpose of this special meeting is to have Attorney Bila explain the differences between police power zoning and blended police power zoning short-term rental ordinances. Mr. Bila will then take any and all on-topic short-term rental questions after clarifying that he's here to provide advice on what the law is and what we can do legally, not what policy position the board should take. As far as board comments coming next, is there something you'd like to say first or?
No, I just,
Okay.
Thanks for having me. Thanks to the public. I just, I'll say, short-term rentals obviously are very, hot topic. And so, I thought it was prudent to, have at least one meeting where we could come here and sit down and, lay out some of the legal points of it. And again, there's a lot of different ways to go about regulating short-term rentals, and I'm not in the role of policymaker. So, you guys decide how you want to regulate and how much, et cetera, et cetera. I'll just tell you the options that are available to you. So, with that, I mean, I have a spiel basically I can run through about short-term rentals. I just was teaching last night in Harbor Springs on planning and zoning. So I talked a little bit about short-term rentals in that presentation, not very much, but certainly I've talked about them a lot, in my practice there all across the state. So, if there's specific questions you want me to address, or if you want me to just give a spiel, however you want to go about it, I'm happy to do what the board would like.
Thank you, sir. I would prefer that you do your explanation and whatever you'd like to do, and then we can move into the board comments and questions before going to public comment.
Sure.
So maybe it would flow better if you did your thing first.
Sure. Yeah, maybe I can lay out some of the. So, short-term rentals, we're all obviously, I think at this point familiar with what they are. But, the rental of a dwelling unit home, an apartment, a duplex, something like that for a period. Generally, it's going to be defined as less than 30 days at a time. Once you start renting a house or a dwelling for 30 days or more, now you're just talking about a month-to-month lease, which is pretty much just a standard residential. So with short-term rentals, we're always talking about regulating something that's a rental for less than 30 days at a time. And typically what you're seeing, with things like Airbnb and VRBO is, a long weekend or maybe a week renting a home. But some go longer than that. So that's kind of the realm that we're, the realm of regulation that we're dealing with here are these short-term rentals. And as a township, at the moment, there is no state preemption legislation over short-term rentals. So the township is kind of open season almost in terms of how much or how little you want to regulate and what specific things you want to regulate. The only things that bind us, obviously, the Constitution and due process, people's rights, and things like that, or rules that are in the zoning act. But generally speaking, we're pretty freewheeling with short-term rentals. There's proposed preemption legislation. Some of the legislation going through in Lansing right now talks about, requiring us to allow them in any residential zone, requiring us to allow them in any zone that allows for a single-family dwelling, requiring us to allow a certain number of them, requiring us to approve an unlimited number of them, et cetera, et cetera. And so, but that's all pending legislation. Let's wait for the phone so everybody can hear me.
Yep,
So-
that was good.
So that's all pending legislation, and none of that's been enacted yet. And so what that means is that for the moment, we're free. And so, then the next question is, okay, well, what can we do as a township? And there's two types of ordinances that all townships can adopt. As a general matter, there's zoning ordinances and there's police power ordinances. And so zoning ordinances, you have a zoning ordinance under the Michigan Zoning Enabling Act. You have a planning commission that's in charge of that zoning ordinance. And a zoning ordinance, the hallmark of it is that it divides the township into districts and then regulates what uses are permitted or require a special land use permit in given districts. And the other type of ordinance that we have is a police power ordinance, which is basically everything else. And so police power doesn't really concern itself with zoning districts. That is just going to apply, across your entire township. And that's where, in the case of short-term rentals, you may find, what's called a police power or a licensing ordinance. And so just like for other types of businesses where you have to get a license to operate, a short-term rental, you can require as a township through a police power ordinance that they get a license from the township board or whoever you designate to operate a short-term rental. So you're always going to have some form of a blended ordinance in the sense that because you have zoning, if a use is not if a use is not listed in a zoning district, it is prohibited. And the courts have held currently that if you're residential, your R1 district says that a single family residential dwelling is permitted and nothing else. The courts have said that does not include a short-term rental. So even though a short-term rental looks like a single family dwelling use, if you're just looking at it in a snapshot in time, it's just a family living in the house. The courts have said that the use of a property as a short-term rental is clearly a commercial use. And so currently, if your zoning ordinance only allows for single-family residential in a given district, that does not include short-term rentals. They would be prohibited under zoning. And so if you adopted just a police power ordinance, licensed short-term rentals, someone would be able to come in and apply for a short-term rental license under your police power ordinance, but they also would have to get zoning approval. And when they went to your zoning administrator, if they were in, say, the R1 district, your zoning administrator would have to tell them that that is not a permitted use because it's not listed in the zoning ordinance. So and I believe I've looked through the remainder of your zoning ordinance. And I don't know that a short-term rental is really contemplated anywhere. So a lot of ordinances don't use the word short-term rental unless they're very recently updated. But a lot of ordinances describe something like a boarding house or a lodging house or transient residential dwelling, or they use some term like that. And, by that, they mean really, by the definition, that is a short-term rental. So just because you don't call it a short-term rental doesn't mean it's not one. And sometimes you'll find your definitions of that boarding house, lodging house, those are the common terms I see, may fit a short-term rental, and it may not. It all depends on how your zoning ordinance is defined. And I believe from when I reviewed your zoning ordinance, this would have been probably a few months ago now. This conversation's been happening for a while, but it doesn't look like short-term rentals will be allowed in any district anywhere at the moment. You have provisions for things like motels and hotels, but those require multiple rooms and they require hotel licensure, et cetera. And they don't really contemplate, just a single dwelling being used as a short-term rental. So when we're talking about a blended ordinance versus zoning versus police power, all that is to say, you're going to have at least some minimum zoning component to let the STRs in, unless, of course, it's your intention to completely prohibit them everywhere, in which case you don't have to make any changes. Your ordinance, I believe, and I look at so many ordinances, sometimes I get them mixed up in my head, but I believe yours doesn't allow them right now. So if you don't do anything, they just remain prohibited. But if you want to regulate them or you want to allow them in certain places, at a minimum, you'll have to adopt zoning ordinance amendments that would place STRs in one or more districts. But the zoning ordinance could stop right there. It could say an STR is a permitted use in such and such district, subject to a license from the township board's police power licensing ordinance. And then, you'd be doing the same thing I described earlier. Someone would come to the zoning administrator and they would be able to get approved for a zoning permit, but then they wouldn't be able to just start doing it. They would have to then go before the board and get the police power licensing ordinance. So really, there are three options, I guess, that I see as the most, practical. I mean, there really are three options. The first one, obviously, which I just kind of described, is to just do nothing. You can just not regulate them at all. The state doesn't require that we allow them, and you can just not allow them. You can prohibit them, or you can only allow them, if you want to put them. I've had some townships put them only in a commercial zone or, something like that. One of my townships downstate has allowed it in their commercial zone only, or they have a highway commercial zone that's kind of along like a big thoroughfare that, again, the courts have said it's a commercial use. And so it's entirely reasonable to say we're going to limit it to a commercial location only. But, that obviously ignores the reality of short-term rentals, which is that most of them are in residential zones. And so if it is the board's intention to allow for short-term rentals in some capacity, if you want to just, again, allow them in the commercial, that's fine, but you're going to be cutting out a lot of people who want to or are currently maybe unlawfully operating a short-term rental. And so if you want to allow those people to operate a short-term rental and you just want to regulate them, then you would have to amend your ordinance, your zoning ordinance, to put them in those other, residential districts. So the first option, as opposed to just doing nothing, would be fully through zoning. So under the zoning ordinance, you have what are called permitted uses or uses by right, and then special land uses. And a special land use, they're all written out in your zoning ordinance. They're essentially land uses that are allowed in a given district, but have a little higher chance of posing a risk to adjacent properties, or have some kind of factor or element of them that makes them, a little bit more intensive or potentially burdensome in that particular zoning district. Excuse me. So for example, you may have in your residential district, a permitted use would be a single family dwelling, because, that's really the purpose of a residential district, is single family dwellings. But you may allow as a special land use, some small type of business, like a small, the example I use a lot is like a barber shop or something, where, a barber shop on its own isn't completely offensive to the idea in a residential zone, but it certainly is quite a different type of business compared to a residential single-family dwelling. And so in that case, you may allocate that barbershop as a special land use and have special extra conditions on it in the zoning ordinance. And if someone wants to engage in that use in that district, they have to get a special land use permit, which requires them to go before the planning commission. There has to be a public hearing. There's going to be notice to adjacent property owners and in the newspaper. And if they are approved for the special land use, they can do whatever it is. They can open that barber shop, or in this case, they could use their property as a short-term rental, subject to all the terms and conditions of that special land use permit. And what kind of conditions you can put in a special land use permit are like almost endless. Typically you would see, maybe mandatory screening or setbacks or traffic control or, mandated off-street parking, noise regulations. It runs the gamut. You can set anything you want in there. And that could be the extent of your short-term rental regulation. You could call it a special land use in certain zoning districts. And just like all the special land uses that you have now in the township, a person would go before the planning commission, request a special land use permit, and then in your zoning ordinance, and I'm not familiar enough, I apologize, but sometimes that also a special land use permit will go to the board, this township board for final approval. Sometimes the planning commission can grant the final approval all on its own. It depends what it says in your ordinance, but either way, as long as they meet the conditions in your special land use standards in the zoning ordinance, the special land use permit essentially must be granted. So it's obviously important then to set standards that you want people to meet, because once they meet them, the permit is almost a guarantee. And the benefit of doing it exclusively through zoning and a special land use process is, mainly I think is the familiarity, where your township should already be used to. Now, some more rural townships don't do a lot of special land use permits, but it's at least something that you do on a somewhat regular basis at the planning commission level. And it's a familiar type of process. Someone applying for a special land use permit, getting a special land use permit, our township zoning administrator should understand what that means. The planning commission should understand how to review those standards. And so exclusively through zoning, that makes a lot of sense from a familiarity standpoint. Now, the biggest drawback really to exclusively through zoning and a special land use permit is, what we would call like grandfathering or lawful non-conforming. So the kind of old school term is grandfathering, but a lot of us attorneys use lawful non-conforming because it better explains what's happening. And so a lawful non-conforming use is if a use was at one time lawful and we amend our zoning ordinance to remove that use, they are allowed to continue at the same level. They can't expand the use or make it, they can't make it larger or cover a wider area or anything. They're allowed to continue at that same level. They have essentially like a vested right to continue, even though they are non-conforming with the current zoning ordinance. So that's why, again, we use the term lawful non-conforming, because I think it helps people understand the point of what's happening better than saying grandfathering. And with grandfathering, for example, some people would say, well, I've been running a short-term rental for years, so you have to let me keep doing it. But the question in lawful non-conforming is, was it lawful at some point in the past? If it was never lawful, you don't get a lawful non-conforming protection because you're not lawful. So, currently anyway, I believe that my analysis was that it's currently prohibited under your ordinance. So anybody using a property, a single family, like residential dwelling in the residential zone as a short-term rental is unlawful. And I don't believe that it has ever been lawful, although, sometimes you can go back like 50 years in your ordinance and find something. But in that case, if you adopted a new zoning ordinance, people currently using it as a short-term rental would not be grandfathered in because they are unlawful, so they don't get lawful non-conforming protection. But if you adopt a zoning ordinance, special land use permit, and then you give people special land use permits, and then later you decide we want to rein back on this, or we want to change some of these requirements, or we want to prohibit it again entirely, everybody that you've let in up to that point on a special land use permit, they are all lawful non-conforming uses now. So if you in the future go and say, all right, we're going to just prohibit short-term rentals again, you won't have any new ones, but all those ones in existence are going to be allowed to continue at the same level and under the rules of their current special land use permit until basically until they give up the use, until they revert back to a single family dwelling or whatever else. So that's the main, from a township perspective, the main caveat to doing it exclusively through zoning is you're going to have people with lawful non-conforming protection. And also a special land use permit is under the law, it's quite a protected thing in and of itself. So even if you don't amend your ordinances to remove a special land use permit from someone, even if they're committing like frequent and flagrant violations of the permit requirements, still requires a process. So you basically have to do the whole process that you gave them the special land use permit. You have to do that again to take it away. So public hearings, and you have to give them adequate notice and the opportunity to appear before the planning commission and explain their, bad behavior, and then decide whether to repeal the permit. And so, the zoning permit, once granted, again, I think just to emphasize, has a lot of these kind of protections. So that is, again, you do nothing and they're just prohibited. You have granting it exclusively through zoning, a special land use permit process. Now, you could also, I suppose, make it a permitted use in a given district and just have no regulations on it and just say anybody can open one whenever they want in a residential zone, and you don't even have to go through the special land use process. It's just permitted. Obviously, I think when we're talking about permitted and special land uses, a permitted use should be something that, like, under all circumstances is going to be appropriate in that zone. And I have not seen many townships that say that about their residential zones, but again, that's a policy decision for you to make. That's not for me to decide, but it's uncommon. But you could certainly say that it's a use by right or a permitted land use, and then anybody could just open one up in the same way that they can plop down a single family dwelling, as long as they comply with, your site plan setback standards and get that, administrative approval from the zoning administrator. So the third option, the final option, is kind of what you've termed blended, and I think is a good word for it, blended police power and zoning ordinances. And this is, I would say special land use has been quite common, but this has also certainly been a very common method of regulating short-term rentals across the state. And really, what a blended ordinance entails is the minimum or more, you can do as much zoning as you want, but really the minimum required zoning approvals. So you say, again, that it is going to be allowed in a certain district, but subject to, you must obtain and at all times keep a license from the township's police power licensing ordinance. So that's all your zoning ordinance says is, yeah, it's in this district, but you got to get a license from the township board. And then the township board will adopt their police power licensing ordinance. And in that ordinance will be all of the requirements to obtain a short-term rental, essentially business license. So, typically what we see in those is, okay, we have like an application window. A lot of townships like to do it on like an annual basis. So like January to December. So starting in like October is our application window. You got to apply. When in your application, you have to list, the property owner. You have to show that you have permission from them to operate a short-term rental on that property. If you're not the owner, like if it's some third-party company or something, we typically then will require, like a local agent. So somebody who, let's say the property owner like lives in Florida. If there's a complaint, we're going to require that they designate a local agent, which is someone in the area who can respond to the property within X amount of time from a complaint, virtually 24/7. So you have to be able to reach the property in 45 minutes, or you have to be within so much of a mile radius of this property to be prepared to respond to complaints as the agent. And that could be the owner as well. And you're going to have, maybe require septic inspections. Maybe you require they have to get approval from the health department to get an understanding of how many people the septic system could support. Because sometimes with these short-term rentals, um, you have a smaller house that is built for a family of 4, but if you just cram bunk beds into every room, now it can fit a family of 20. And so, yes, they can physically fit in the space, but the question is, will the septic support it? And that's especially important around, lakefront areas where you have a risk of a septic system failure, leaching into the lake and causing a problem. So we can require septic inspections, which would then set a maximum occupancy limit of whatever the health department says is safe. We can set our own maximum occupancy limits. I've seen some townships that will set, you can only rent X amount of days during a given week or month. Quiet hours, which generally is governed by, some kind of a noise or a nuisance ordinance anyway, but sometimes we stick it into the short-term rental ordinance as well. Off-street parking requirements, you got to have so many spaces for however many people you anticipate to be there. So we don't clog up the roads and make it impossible to drive down. And much more. I mean, I could go on, and there's all kinds of regulations that you can establish in the police power ordinance, the licensing ordinance, that would govern short-term rentals and essentially try to allow them, but combat some of the problems that we see with short-term rentals, which is like noise and traffic and, like capacity issues, health and safety capacity issues, things of that nature. So that's probably the most common one I've seen. And the benefit of the police power part of it is that a police power license is much less protected than a special land use permit under the law. So it is not something that we can repeal just willy-nilly, but it is more straightforward to repeal than a special land use permit. And we still have to give the property owner a fair warning of why we would be considering repealing their license and give them an opportunity to contest our findings. But they also, unlike, a special land use permit, which generally is just going to continue on as long as they do the use, the police power license can expire after a year. And so you may have, if you have a person who's been causing problems, rather than try to repeal their license, you just wait until the end of the year, the license lapses, and if they don't renew it, they don't get to keep operating as a short-term rental. Or if their license lapses and they come for renewal, then we can address, the problems that we've been seeing and maybe deny them a license on the go around. And people have less of a legal right to a police power license than they do for a special land use permit license. So the other benefit of the police power license is it is entirely through the township board as opposed to the planning commission and the township board. And so granting the licenses doesn't necessarily require, like the public hearing, the public notice and things. Now, you're welcome to do as much or as little noticing as you want, but to grant someone a police power license like that, I mean, you could be as straightforward as pure zoning administrator approval, or if you have a special short-term rental person where if they submit an application that meets all of our standards, the short-term rental officer will just grant the license. It doesn't even come before the township board. A lot of times I've seen it that the township board likes to at least have a look at it. I don't think that's unreasonable. But typically, you're just looking at, okay, have they met all the standards that we've established in our police power licensing ordinance or not? And then determining whether to grant them the permit. So those are, when you're talking about the difference between the zoning, the police power ordinances, hopefully that was obviously a very belabored explanation, but hopefully it made some sense. And, the other item that I would point out as far as a police power ordinance, which is true of a special land use permit as well, although it's easier, is in a police power ordinance, any regulation that you are writing into an ordinance, you have to be prepared to enforce. And So, if we can have these grand ideas about writing a lot of regulations in our ordinances that will really protect and limit these short-term rentals, but the question is going to become who is going to go about enforcing that? And a lot of times it's going to be, I mean, I've seen in some townships, I don't know the extent of how many short-term rentals you have. If do you have an estimate of how many short-term rentals are in the township? Just at a guess.
Depending on who you want to listen to, 50 to 85.
Okay. Yeah. So I've seen, some townships that have, I mean, that's a lot, even for this size, but I mean, I've seen some that have as many as 200 or 300 currently operating in what's a pretty rural township. And so, you're going to have an individual who's prepared to, inspect and review and enforce and monitor 50 to 85 to maybe more short-term rentals under, I mean, whatever scheme you engage in, but particularly in a police power license where you're going to have a lot of those kind of regulations, it's easy enough to enforce the regulations at the application phase because you just ask them to give you proof that they've done all the things in the application and then it's done. But if you're talking about questions of like noise or if they're allowing too many people onto the property when they're not supposed to be, if they're parking where they're not supposed to be, any of those kind of issues, you're going to have to be prepared as a township board to budget and give the resources to someone, an ordinance officer, an STR officer, to engage in that enforcement, and it can be very, very costly. So with a special land use permit or with a police power license, we're allowed to ask for licensing fees, and certainly I recommend that you do. And those fees should cover and are allowed to cover, what I believe the law this says something like, the application, administration, and enforcement of blah blah blah. So we would accept or we would set our fee schedule in an amount that covers not only our costs to review the application and to hold any required board meetings, to send out any notices we want to distribute, to review the license, to do the inspections if we have to go out to a property and look at it. We want to cover those costs, but we're also allowed in those fees to use that money to engage in enforcement. So, it's just as much if you're a short-term rental owner who's doing it the right way and has gone through the license, you obviously have a strong interest in the township enforcing against somebody who's doing it the wrong way because you went through all the trouble of getting the license and doing it the right way. Guy is just doing it and nobody's stopping him. So the fees are permitted to cover, as I said, application, administration, and enforcement, but you're going to have to be prepared then to actually engage in that enforcement, and it can be quite a drag. And again, with any regulation that you write and talking about having to enforce them, some of the regulations you might consider, especially things around noise, are going to be quite subjective. If it's a parking violation, if they have to park off the street and they're parked on the street, that's not admittedly very challenging. But with noise, it can be quite a temporary violation. The neighbors may report it, but by the time you get there, it might not be there. It might be noise at a level that is not really offensive, and the neighbor is just upset because it's a short-term rental, and so they're mad about any noise, even if it's a noise level that would be typical of a single-family house. Or, you could have noise levels, where people like frat people rent out parties and have giant parties and have a bunch of noise. That's obviously, I think, a nuisance level of noise that would violate any reasonably drafted ordinance. But the question is, how are we going to actually go about enforcing that and against who? And you just got to be prepared to budget for that. Especially with the police power ordinance again, because you're going to have a lot of regulations involved in that, and even the special land use permit. But you've already got your zoning administrator who's hopefully kind of versed in how to deal with those. So with that, I have certainly, yammered on for a long time, but hopefully I've explained kind of the differences between them. And I know there's been some there's been some confusion about stuff. So again, I appreciate the opportunity to come here in person, and obviously I'm very happy to answer any of your questions from the board. And then, typically, like for public comment is really just a comment period to the board, and we don't respond. But, in meetings like this where it's of the public interest, I'm certainly open to responding to questions from the public, but that would be, a decision of the board whether to allow that or not.
Well, excuse me. Thank you, sir. And don't worry about the length. I am amazed that you did that without notes.
Well, yeah,
You've given me faith in the legal system.
yeah, I've worked on it a lot, so it's all stuck in my head.
Okay, then I'd like to move into the board comments before we get into any comments from the public. Mr. Beal and I have had, I've driven him nuts with emails and conversations, and I just want to clear part of my misunderstanding on the police power zoning might be related to the chickens thing that we all went through. That after the PC input was received on the ordinance draft for chickens from the township board, that we could then approve, enter into public hearings to discuss it all or disregard before adopting an ordinance language addition. And I probably took that a little too far in this process. But I think today it's important that the understanding level between the two, the police power and the zoning, I think it's important that we increase at least the board's understanding level of our options, because there's so much out there. But what it's going to boil down for us is what are our options right now. And to be clear, the township board just passed a motion to pursue short-term rental in a blended zoning police power ordinance after not doing so as police power only, which I think you're aware of, but
Yeah.
restated. Okay. So some assumptions, two assumptions. You have relayed to me that, and I think this is correct, but I'm going to say it again. The only reason to use zoning, other than publishing the short-term rental intent in the zoning 55 language, is to potentially restrict areas. For you, is that a yes or a no? And I don't mean to put you on the spot as much as.
Yes. So the problem is, like I said, if you're using it, if you only adopt the police power ordinance and change nothing else, if a person applies for a license under the police power ordinance and they meet all the requirements, we would give them a license under the police power ordinance. But they're also going to need to go to the zoning administrator for whatever they're doing and get zoning approval. And the zoning administrator would be forced to say no because, yeah, the police power licensing allows it, but if you look at our zoning ordinance, it's not a permitted or special land use in the given district that they're in. So at a minimum, and admittedly, this may have been misunderstood or misspeaking or something on my part. Because when I talk about police power zoning ordinances, using that exclusively, I guess I would have misspoken to say it can be exclusively police power and nothing else, because you need at least a minimum zoning component to allow it in the door if you have zoning. So, that may have been, a mistake I made, or, I know we've had many conversations about it.
I'm sure it's me.
So, you're going to need a minimum zoning component to just pick which district it's going to be put in or not. And then the question is, okay, how much more of a zoning component do you want to go all the way up to where it's completely under zoning special land use? Or is the only component of zoning that you have picking the district that they, adding the word short-term rental to whatever district, and then saying, of course, subject to the Lyon Township licensing ordinance, and then adopt the licensing ordinance separate. So there's going to always be a minimum zoning component. And yeah, again, certainly
I understand that better now. So to save some time, I'll get into some scenarios. I'm hoping like a yes or a no, just to clear it in my head, but I recognize that's difficult for you. The township board created a short-term rental draft and sent it to the planning commission. Planning commission returned it with, by my count, 16 changes or omissions. So, two questions. Can we now, as a board, and these, I'm not saying this is what we'll do. I'm trying to clear up what we can do.
Sure.
Can we now, as a board, just adopt the original board's short-term rental draft as is, and then make the amended change in the language for zoning 55 to reflect the short-term rental ordinance is now established in Lyon Township?
So yes, with another public hearing at the board level. So if every zoning ordinance amendment, I probably should move closer to this microphone.
Actually not, because it'll blow up.
Oh,
It's pretty good on distance.
all right. I'll keep it at a distance then. Good to know. So every zoning ordinance amendment, anytime you're going to change anything about the zoning ordinance, no matter how small, I mean, I even almost say down to a single letter, it's going to have to go before the planning commission first. And they have to hold a public hearing. They got to publish the notice and in the newspaper and hold the public hearing, allow people to comment. But the planning commission, ultimately, what they produce is only a recommendation when it comes to amending the zoning ordinance. So the planning commission will recommend amendments then up to the township board, and the board then has the authority to adopt the planning commission's recommended ordinance and changes as presented. Or if you're going to not adopt them at all, you can also just do that and just say, we're not going to take it at all. If you're going to adopt it, but with amendments, the law, the Zoning Enabling Act just requires that you hold another public hearing at the board level, the same way that the planning commission held a public hearing at their level, in order to ensure that the public is fully informed of what ordinance is actually being passed. So really the theory behind it is, if the planning commission is presented with an ordinance that says, you know, just as an example, we're going to allow tables in this specific building. And they send it up to the township board, and the township board, you know, at a special meeting or something, modifies it and says, actually, we're going to allow short-term rentals in every single district, and we're going to allow, you know, drag racing courses across the lake, and we're going to eliminate every single housing property, and that's the ordinance we're going to adopt. You know, the statute basically just contemplates that as kind of a bait and switch, where everybody who attended the planning commission public hearing had a certain idea of what the ordinance was going to be about. It was about tables in a building, and yet the board has like completely flipped it on its head. So what the law says is, like, okay, whatever the planning commission sends you, you should consider, but if you're going to adopt something that's quite different from what the planning commission put forth, you should have another public hearing, because the public should be informed and given an opportunity to comment on what is actually going to be adopted by the township. So if the board makes a few minor changes to an ordinance coming up from the planning commission, you know, I've had like a board add in a definition that was missing, or maybe change one or two numbers slightly. You don't need to hold a whole nother public hearing, because the public was pretty well informed at the planning commission level of the scope of the ordinance, and you're just making some minor amendments. But when you're starting to change, you know, when you're talking about on a scale of 16 different things, you know, again, I think there's arguments to be made that you don't need to have a public hearing, but the more changes you're making, the more I err on the side of caution and saying that whatever comes before the board, you would have another public hearing, discuss discuss what the PC put forth and then what the board put forth, and then vote on which one you want. And then once you vote on it, that would actually amend the zoning ordinance, you know, as described. So they wouldn't have to go like back to the planning commission again. Although you are free to send it back to the planning commission if you want them to provide more input or different input, or research a specific issue closer or something like that. You're more than welcome to send it back to them and have them review it again. But you can hold your own public hearing and change the ordinance right at the board level.
Thank you, sir. So you answered a couple more right in there, trying.
I'm just
This is a little different scenario, but the same sentence starting. The township board created a short-term rental draft, sent it to the PC. PC returned it with 16 changes and omissions. Can the township board take the original board short-term rental draft and make no more than 2 to 3 changes, then adopt it without going back to the planning commission?
Yeah. So you could certainly adopt it without going back to the planning commission. But again, I think I would want to know the scope of those changes, because the more drastic they are, the more I lean towards wanting a public hearing at the board level. But if the planning commission has considered the amendments, and especially if they started with a board draft and redlined it and then sent it to you as a red line, you know, to revert back to what was originally proposed, I think the public obviously has very fair notice of that, because that's what was in front of the planning commission to start with. But again, the more changes you're making to what the planning commission recommended, the more I want to hold a public hearing, but it does not have to go back to the planning commission at that point.
Okay, and if, again, these are options. If we were to do that, then the board, the same as the zoning 55 language protocol with the chickens, the board could then make the change in the zoning 55 language or ask the planning commission to make that change. Chickens, we asked them, but then they didn't.
Yeah, so the ordinance itself that you're adopting should say in it, one of the sections or all of the sections should say, you know, ordinance number 55, section 5 is amended to say short-term rentals are allowed in this district, such and such district.
Okay.
So the ordinance that you're adopting should say right in it that it is amending your zoning ordinance. And so once it's adopted by the board, I mean, it does actually amend your zoning. It does exactly what it says on the tin, as far as if it says it amends 55 section whatever, it just does it. And so then whether or not you have someone actually, you know, who goes and physically types that into your ordinance and re-uploads it to the website is, you know, an administrative thing. But the ordinance itself is actually changed. But the language should be in there that ordinance 55 is being amended, because again, that's the whole problem that we're running into with the short-term rentals, with police power or whatever, is that they're currently not allowed in the zoning ordinance. And so the zoning ordinance itself has to be changed, and the language in whatever ordinance you're adopting should say specifically what sections are being changed and how.
Okay. This one, I think you already answered in this process, but same lead in. Township board created short-term rental draft, sent it to the PC. PC returned with 16 changes and omissions. Can the township board take the PC draft and reverse any or all changes, or return any or all omissions from the township board draft without holding public hearings? And I think you're clearly saying if it's more than a couple.
Yeah, if it's more than simple things, I mean, you know, this is kind of a more unique situation in that the township board had an ordinance presented to the planning commission at the start. And so, you know, arguably the public was aware of the content of the township board's ordinance and the planning commission's changes to it. And so, like, arguably to go back to the original township board level ordinance, the planning or the public is well aware that that was a possibility. But again, I think generally speaking, if you're whatever recommendation you get from the PC, that is what I look at as what you are changing, as whether to have a public hearing. So if you adopt the planning commission's 16, you know, ordinance with 16 changes / omissions, then you know, you don't need to hold another public hearing, because that's exactly what the planning commission had sent up to you and what was at their public hearing. And again, if you do one or two little things, I'm not too worried about it. But yeah, if you're going to revert the whole thing back, you know, I would really like to be a public hearing, especially, you know, and I like there are certain things, you know, if it was an ordinance to regulate something that was really minor and not controversial and didn't didn't have any real influence on a lot of people, then, you know, you can maybe get away with being a little more lax, but especially when you're talking about short-term rental stuff, I really would prefer to err on the side of caution. Because I mean, you can see by the public turnout today that there's a lot of public interest in it. So I want to make sure that everybody has an opportunity to present on what's actually going to be adopted.
Okay, and I think you already answered at least my next question. So I won't get into that. So we now passed a motion for a blended short-term rental. We passed that motion. Now, in the scenarios I already ran down about where we're already in this process with the planning commission, does anything in the fact that we passed a motion saying we would do a blended short-term rental have any bearing or influence on those scenarios? I think I understand, and probably not much better, on how both work. For lack of a better way, does us passing that prohibit any of these scenarios?
No, not really. So, the motion, the motion, and you sent me the text of it. I mean, admittedly, it doesn't really say anything other than an intent to go forward with something, but like that will never bind you, to anything. I mean, you could tomorrow adopt purely a zoning ordinance setup, not blended at all, and it's not unlawful. You know, the motion doesn't legally bind you to anything. It just says, here's kind of where the board is standing on the position, but you certainly don't have to follow that.
Okay. I believe that's all I have questions for you, but for the public,
Well, and do the other, I don't know. If the other,
yeah, they do, but I just wanted to make, the original short-term rental draft from the board, which is now over a year old, was put on the township webpage under the ordinances, but it's not an ordinance, so I think Jonette put it up near the top, so it's been there. Realizing that might be a little hard to find, we now have paper copies of that short-term rental draft available, and you can find it. I believe it was reposted. Did you put it in a different place too on the web page for the short-term rental? Okay, so it's no, so it's there, and if you want paper copies, we have paper copies here. The planning in the office. The planning commission version that they gave back to the board is still in flux, but I felt it needed to be out there somewhere. So we added it to planning commission minutes. Do you remember the date? So it would be in the, okay. So it is now included in, if you go on the webpage and look at our planning commission for that November meeting, their version and the changes they made is there. So the public should be able to get either one of these. I didn't, just letting you know that's what happened. So they're available. So thank you for answering my questions. Other board members, I'm sure have some.
Just let it go. No. No. Mr. Vila, I would like to know how little we can get away with doing to add part of the zoning to allow the STRs in R1 and then incorporate police power for the enforcement of the various things we have to enforce without having to go back to the planning commission. How little or how much can we do?
yeah, so you can't make any changes to the zoning ordinance without going to the planning commission. Even, I mean, as I said, down to like one letter, unless it's like essentially a typo. like an obvious typo that doesn't change the meaning.
Alright.
Otherwise, anything that changes the meaning, changes any uses, anything like that has to go in front of the planning commission first, public hearing, notice, and then up to the township board for approval. So if you, like, the planning commission has already done the public hearing for this first scheme, excuse me, that that Paul was talking about earlier, but if you wanted to amend the zoning ordinance and just have like one sentence in there that says, STRs are permitted subject to the licensing ordinance, that still has to go in front of the planning commission, still have to go to a public hearing,
Okay,
even though it's only one sentence, and
Right.
even though everybody knows
okay.
about it. That's just how the statute's written. Any amendment to the zoning ordinance has got to be that full process.
That is about as plain a question I could give you, and I got a wonderful answer. Thank you very much.
And how long have we been talking about it?
Well, that's why it's nice to
No, that's,
you
that
know?
clears things up. Everything else is.
Just a couple from me. If the township board decided to say, we don't want any short-term rentals, zero. So we're gonna pass an ordinance. This is hypothetical, of course. And I'm not sure if I heard you correctly, but even if we said there will be zero, the people who currently have them will be able to keep them?
Okay, yes. So
Maybe I heard you wrong.
so this is, I understand it's quite the opposite. So the grandfathering is lawful non-conforming. So for someone to operate it, it had to have been lawful at some point in the past, and they have to have been operating it since that point in the past until now consistently as that use. So I believe right now in your zoning ordinance, they are not allowed in the residential district. Like I said, the residential, like R1, allows a single family dwelling. Courts have said that's not a short-term rental. And I think looking over the other parts of your ordinance, nothing else talks about short-term rental. So like, for example, anything in the R1 right now is unlawful.
So even though there was a previous short-term rental, that doesn't matter.
Yeah, even though they have been operating for a while, that is not, and that's why I don't like to use the term grandfathering, because people say, I'm grandfathered in, I've been doing it forever. And it's like, well, no, really the question is, were you ever lawfully doing it? And then have you been doing it consistently ever since?
So technically, before they were lawful,
Well-
because there was a short-term rental ordinance.
Let's let the conversation happen here.
I believe, maybe I'm.
Well, yeah, so you had a short-term rental ordinance that you guys repealed right when you got on the board, right? So it was lawful, but somebody would have had to have applied for and gotten whatever that license was in that like 2-week span that it was allowed. So I don't know that anybody actually did that.
Yeah, okay.
Because that would also be, if that, and I obviously I helped draft the language that repealed that ordinance, but I don't know that I read it that closely because we were just repealing it. But if it required any kind of a license or approval or anything like that, then you don't get the protection of it until you go about getting the license. So just because that ordinance was in effect, if we didn't grant anybody a permit under it or a license, then nobody made themselves lawful. So now everything's still unlawful, I would say.
All right, and I just had one more. When it comes to the application process, and if there is, say, we have 80 right now, and we say, we're only going to allow 25. First 25 people will come,
Yes.
get accepted. Is there any legal repercussions that the township gets from the other 60?
Much so. So and I'm glad you brought that up, because that was the other thing I was going to say about for a zoning ordinance, for a special land use permit, typically you're not allowed to set a cap. So a special land use permit is just anybody in that district can apply for and get that permit. You're not allowed to set a cap on the number of special land use permits you give out for a given use. If it's in the ordinance and they meet the standards, the permit must be granted. So if it's only through zoning, special land use permit process, there's no cap. Now you can still set like distance requirements and make an effective cap by saying they have to be at least 1,000 feet apart. And then if somebody applies and there's already another one in 1,000 feet, you tell them no. But for the police power ordinance, you can set a licensing cap. You can say we're only going to issue, like you said, 20 licenses. And so, there's I mean, a mountain of problems with that. So it's entirely lawful, but whenever you're picking winners and losers, the losers are going to be upset. And with short-term rentals, there's a lot of money at stake for some of these people. You can rent some of these properties, especially if you're out on the lake or something. I mean, you can get like 10, 20 grand a week out of some of these rental properties. And so when you're talking about you're denying someone a license under the cap, I mean, for any reason, but including under the cap, is maybe where you're going to deny the most licenses. All of those losers are $20,000 a week in the hole, essentially, on your determination. And, they could very well sue you. And again, the cap is lawful. You can have a cap, and if they sue you and it is the sole legal issue, I would say we would win. But the problem is, how are you picking those winners and losers? And that is where the fight gets really complicated, because if you have 80 applications all come in at once and you're only going to pick 20, now you've got to set standards in your ordinance on how you're going to score those ordinances. How are we going to say who's better than another person? And some townships say, well, let's just do it by time. When whoever comes to the door first gets the permit. But even when you're talking about regulation by, first come, first serve, basically, the question is, well, what does it mean to be the first one to arrive? Is it just the first person to walk in the door? Is it the first person with a complete application? And what if, if you're requiring health department inspections, maybe Paul can get an inspection next week because he's scheduled in advance, but Greg can't get an inspection for 2 months. So now he's getting kicked out just because the health department, who none of us can control, is scheduling out long. And so then it's like, okay, well then do you want to say the first completed application is the first person with all inspections? And so you get all these complicated things about running a cap. And again, everybody who loses, even if you do everything right, there's a few honest people, I think, who would just accept the fact, but most of them probably are going to try to challenge you or sue you. And then it's going to be, into legal fees and discussing how to defend your decision. And, God forbid, like maybe somewhere along the way we made a mistake. Now you're really in a pickle. If somewhere along the way we delayed responding to a guy for 3 days, and that was what put him past the line for the cap. So yeah, I mean, the short answer to your question is, yeah, having a cap certainly creates a lot of legal.
So even if we change in the R1 district, we say, no lakefront short-term rentals, it's any fun. Is that legal? Like when we go to limit them, you have certain districts where they would be, and if you happen to be in the one that's not allowed, then you can't have one.
That's fine. So that's just zoning. So that's just straight zoning. So that's a classic. Stuff is allowed in some districts, it's not allowed in other districts.
You could use it not to limit them.
Yeah. Oh yeah. Yeah. That would be one. I mean, that's the main way, in the zoning part, to limit at least where they're going to be located. And like I said, I have some townships that say it's going to be in the commercial district only, and their commercial district has some houses for whatever reason. And so maybe they say it's in the commercial district only, and so they have a lakefront district, not allowed there. They have R1 district, not allowed in any of those. So it is allowed, but just in the commercial district, that's totally lawful under zoning. Again, you have people that will complain, and I'm not going to say that you won't get sued, but people. I mean, the beauty of the American legal system is anybody can sue you for any reason at any time. Just got to deal with it,
Yeah.
no matter how wrong they are. So, but that is a classic. I mean, right now your zoning ordinance says, in the R1 district, you probably can't open up like a slaughterhouse or a factory or a steel works or something. It's the same thing where, yeah, uses are going to be divided up, and some places they're allowed and some they're not.
Just kind of back on the end of Kevin's comment, if we did ban the lake STRs, that's the big bucks you're talking about.
Yeah.
The giant houses that have gone up around the lake and on the lakefront, boy, I see trouble there. Okay.
Yeah, and so you can, I mean, right now they are prohibited, so you just keep them prohibited. But again, going back to the question of enforcement, you're gonna have to be prepared to fight people if you want it enforced, you're gonna have to be prepared to fight people and probably get into court. And now we work in Roscommon County courts a lot, and I happen to know the judge is actually, he's a very good judge as far as municipal stuff is concerned, and he's made good rulings for us. So, we have that benefit, but it doesn't mean it's a walk in the park by any means. And you're still going to be talking about legal fees and things to get what you want enforced.
So that brings up one more scenario for me then. If we did a blended version with police power, and then the language in zoning in 55 gets changed to allow them in R1, and we don't put a cap on it, and the process proceeds, and we end up with arbitrary number, maybe there's 65 of them who we have given permits to, and we're looking in the next year now. And it appears that this is a big problem, and maybe we should consider restricting it so it doesn't get any bigger. Could we then, as the township board, and let's say we have 65, we'll just use that number, 65 permits are out there, then say, okay, this is not trending in a direction that we're liking. We're going to put a cap of 70 on it, where we're not excluding anybody who is currently in. And then when we hit 70, that's it. It seems to me that eliminates some of the wrangling on who got there first and all of that. And I'm not saying any of that's going to happen. I'm just saying a scenario.
Yeah.
That in itself, if we were to do that and cap it later above what we currently have, not say we're going from 65 to 50, we could do that reasonably easy.
Yeah, and so I actually have another township just a little bit further north of us here that did a short-term rental ordinance, and for the first year they had no cap, but in the ordinance it said at the end of the first year the cap is going to become however many licenses we have doled out. And so they had no cap. Anybody could come in and apply as long as they met the standards. They got a permit. And then starting the second year, that was our cap. And so now if new people come to apply, we put them on like a wait list and say, if a license drops off, you're going to be on the wait list in this order. And again, we had to discuss, okay, what does it mean when do you get to be put on the wait list? What position? How do you get your position? But now we have, everybody got in who wanted one. They're in the early, we encourage people to just come in and get one. And then we've even had a few, we had some short-term rental people who said, you know what, I do it every once in a while. I don't even really want to go through the trouble. I'm just going to stop short-term renting my property. And we've had some licenses that have lapsed, like people who haven't renewed them or have failed to comply with certain provisions. So they lapse, and then we're starting to pick up people off the wait list. But now it's more of a settled position that we're in, I think. And that's still, they just like 1 or 2 months ago got to the end of their first year where they're now in the process of engaging in the cap. So like, I'm not going to say that's the holy grail of ideas because I don't know how it's going to play out, especially over the summer, but that is one way that they've done it to say, these caps, we're going to set these caps this way. And then again, the other benefit of the police power ordinance is, the permits will usually be on a yearly renewal cycle, and there's a lot less protection on a police power license. And if it comes to the end of the year and the board says we don't want to renew any licenses, you just don't renew any licenses. And I will say you're almost certainly going to be sued, but I think it is lawful to say we're not going to renew any licenses. Your license was only good for a year. You knew it going in. It says it right on the top of the page. And, we've just decided the short-term rental thing is not, as you said, trending in a direction that is working for us. And so that's kind of a benefit of that versus the short-term rental, through special land use where they maybe have some grandfathering. And then there's some debate, I think, about whether you can be a lawful non-conforming through like just a permit and not through the zoning and stuff. But again, I think you're on a better footing to just cut the whole thing off and forget it ever happened under the police power compared to special land use.
Okay. Which brings up another question we've been on this for a year. There's a lot. whoever decides that they want to rent their cabin to family members or somebody else, I guess, for 2 to 3 weeks over the course of the summer, because they only use it on big weekends, in order to help them, offset costs for something. What is the enforcement if we get a complaint, a signed complaint to our ordinance officer? These people are renting their place out as a short-term rental. They do not have a permit. Where is our enforcement come into play there, if at all?
Yeah, so it's going to be depending in part on how short-term rentals are defined in your ordinance. And so, like, I think obviously on the one end, like letting your family stay at your house for free is not a short-term rental. But if you're letting family members stay at your house and you're charging them money, now you're probably leaning into a short-term rental. Now it'd be defined in your ordinance as, probably something like that. I mean, if you're charging them money, at that point you're running a commercial kind of an operation. So, if you get a complaint and you have to investigate it, I mean, this is one of the, like I talked about earlier with enforcement, this is one of the biggest issues of enforcement, especially is if they're renting it out by word of mouth, a lot of our enforcement is going to maybe come, or a lot of our identification is going to come from people who are putting it on Airbnb or VRBO or whatever. But if they're renting it out by word of mouth, I mean, we got no like evidence per se of anything that's happening there. I mean, there's people there, but we don't necessarily know the relationship between those people and the owner. And especially if they're family, it's like, how can I know from looking on the outside that there was some payment going on there? So the enforcement of that is going to be very challenging. I think if it's being posted on places like Airbnb and VRBO, the ordinance is going to plainly say that's not allowed, and you're going to be able to knock those off. But those smaller ones that are word of mouth or just to family for like 2 or 3 weeks, I mean, enforcement's going to be very difficult because what comes to my mind, obviously, as an attorney, like I said, we have a good judge, but he wants to see some evidence. He's going to need to see some stuff that says they're short-term renting it, and how we go about getting that evidence is like, I wouldn't even know how to get some of that stuff besides, I mean, we could have our zoning administrator go over and knock on the door and say, are you the property owner, and ask them some questions, but that I would already be pretty uncomfortable with that as a scenario. And so, that specific situation, I mean, it's very challenging, especially like I said, to family. And the enforcement, the enforcement of that kind of thing can just be very, very tricky. And I don't necessarily have a good answer for how to go about doing it because it's just not something that's easy to do.
It leads towards the other, we've had many conversations about ordinances and the fact that we can get complaints and then we can decide to act on them or not.
Yeah.
We'll just fall in the same category where we get a complaint. But maybe as a general idea, we're not all that concerned about family renting out to a family.
Yeah, so we've got, we as a township have total discretion on whether or not to enforce our ordinances. The courts have been explicitly clear over the years, and I've personally litigated half a dozen cases where people sue the township that I represent for not enforcing their ordinances, and every single one of them is a loser for them because we just, it's the same way that you can't force a prosecutor to bring a case against a criminal. It's the same exact logic of you can't force us to bring zoning violations against anybody, no matter how egregious. It's just totally within our discretion, basically. So that would be the same thing where if we get a complaint and we investigate it a little bit and we think we've got enough to go forward, we can choose to go forward. If not, we can just choose to say, this isn't a complaint that we're able to investigate, or, we don't think we're going to be able to prove this up to the need that we need to report. And yeah, that's perfectly lawful. And again, I've litigated some of those cases, so people will sue you about it. But I personally, at least, I've won every single one of them, and I think the law is very clear. So yeah, we can always choose not to enforce, and neighbors can always sue each other for nuisance type things if it's a real problem just for them, or if it's a big noise And I forget if it was, we were talking, if I was talking with you about a noise ordinance, adopting a noise ordinance at some point, or if that was somebody else around here that I was
Well,
talking.
we talked, ours was 11 o'clock. We had, you and I had conversations
yeah.
about, the police and
So it could be, you have them just call the police under the general kind of noise ordinance violation. You just forget the short-term rental thing entirely and just say they're just being noisy and that's just not lawful and have the police come out and talk to them. But yeah, long story short, yeah, the enforcement is challenging for those kind of.
you insist. You should tell me the same thing you told me a year ago.
Wow, it's yeah,
That's pretty good.
that's not
That's
bad.
all I got for now. I don't know about you two, if you got any follow-up questions.
Not I.
Good.
Okay, well then we can open it up to public comment. And again, on topic, short-term rental questions, and we're not getting into what we're gonna do. It's more about him explaining possibilities. There's certainly a wide area of things we're gonna choose from when we make a decision. Let's not get into that. But if any of you have any questions for Mr. Beela, he's here. Pardon me? Is anybody hearing it in the back speakers? It might be the one volume control there. If you want to bump it up a little bit, I'll just keep talking at the same tone and see if it starts coming out of the speakers at any point. The big round dials that are there. So if you're turning it up, you should start hearing it back there. And if not, it's the other round dial. Right, but you can try both of them and I'll just keep talking for a little while, which isn't hard for me. And if it's, when you start hearing it in the back corner, just let us know. Because if you're not, then we may have a problem there we're gonna have to look into. Nothing yet?
Nothing.
If I get real close, well, that works.
Okay, yeah, we gotta try
I
it
don't
once you
set
get,
up online, I guess.
yeah, that's the problem. When you do that, then the recording is muddied up. So we're trying to find a sweet spot, but I can't speak up anyway. So for board comments, try and limit it to the on topic and not the specifics of where this township might go. But God bless America, Mr. Beal is here and we pay him, all of us, for his advice. So here's your shot. Who would like to come up and converse with Mr. Beal about this? Right ahead, Patty.
Patty Dennis, Lyon Township. I'm curious from your experience, because I know you talked about how, the enforcement is a challenge and can be expensive. I wondered if you had any, from your past experience, had any experience with how many hours an ordinance officer would have to be budgeted for 60 or 70 rentals, that kind of thing, because
Yeah, so what I've seen, and I have a few townships that do it. Honestly, in pretty much all of them, they have had to hire a full-time short-term rental enforcement officer, and that's all that they do is, especially, I think in the first year is the worst, maybe not the worst, the most busy, certainly, because you're getting a big influx of licenses. And then generally years after that, it's like 1 or 2 licenses coming on and off. And the enforcement stuff, but the first year is a huge thing. So I have had, again, pretty much most every township has hired, if not a full-time person, at least a 20 or 30 hour a week person to handle just the influx of applications that come in the first year. And then I think they're planning on, stepping those people down a little bit. But I mean, yeah, you're looking at, and some townships have said like, oh, well, we already pay an ordinance enforcement. We already pay a zoning administrator. And it's like, okay, great. But every hour they're dedicating to short-term rentals now, they're not going to be able to dedicate to whatever it is they were doing before. So you have to be prepared for them to throw everything else by the wayside to deal with your short-term rental thing. And again, you can get, if you're doing short-term rental licenses, you can get the fees from people. I mean, I've seen fees of, I mean, $1,000 is probably a minimum, and that just covers your costs of publication if you're doing it that way. But I mean, I've seen fees of like $5,000 for at least the initial permit application setup stuff. Um, because that is just honestly how much money you need to set aside. And maybe for the renewal,
Yeah.
you know, for the renewal, it can maybe be less, you know, if there's less effort to go into the renewal, but um, you know, it's a very expensive process and the licensing fees are allowed to cover those costs, but you're also, you know, you got to be prepared to a certain extent to just commit some money to enforcement and you're not going to maybe see that come back.
Thank you. And so it seems like the least expensive thing is to not get into the business of short-term rentals.
You know, like kind of, I mean, it's also like right now they're prohibited, but people are doing it. And so even now there is enforcement costs that we'd have to consider if we wanted to engage in enforcement. And the question's usually easier when there's no ordinance or anything and they're just straight up unlawful. You know, but that, I mean, right now, if you wanted to like clean house and you have 60 to 85, I mean, you're talking about 60 to 85 citations and 60 to 85 essentially lawsuits in court. Now, citations are less effort than a lawsuit. And like I said, we've been in this court before on these kind of things in other townships in Roscommon County. So I know they're familiar with the stuff, but I mean, even now, if you want to actually enforce your prohibition would be expensive. I mean, the cheapest thing is to just do absolutely nothing and just let short-term rentals keep going unlawfully and you just kind of cruise on. But you know, at the end of the day, we are in a business of zoning and planning. And so,
Yeah. And so that leads me to I'm still kind of confused about the planning commission's role versus the board's role. And I know because it appears that this board doesn't agree with the planning commission's recommendations on a couple of items.
Mhm.
And so I'm just wondering if that's a normal thing or, you know, I know nothing's normal. I know
Yeah.
that, but it's like, if, so this process is going back and forth, and what I heard you say is that that has to continue to go back and forth if they don't agree, right?
so any amendment to the zoning ordinance has got to start at the planning commission. And whatever they recommend to the board can adopt it or change it or ignore it entirely. I would say for like 90% of cases, whatever the planning commission sends up to the board is adopted without much change. And I think that's probably true even here in Lyon Township. I mean, in every township, because 90% of the decisions are not very controversial.
Right.
But for those 10% that are controversial, you know, the board is the ultimate authority for adopting and amending ordinances. So even though the planning commission deals a lot with the zoning ordinance and puts up a recommendation, you know, the board is the one who ultimately makes the decision one way or the other. And so it is not uncommon for a board to get what the planning commission has sent and say, this is not in line with our board policy or how we want to do things, and we're going to change it. I mean, the statute specifically allows for it and describes the process for it. So clearly they contemplate it.
Yep.
And again, for more controversial issues, you know, the planning commission is an appointed group of individuals. The township board is elected. And so as elected members, you know, they have, you know, arguably maybe more of a finger on the pulse, I guess, of what the citizens want. And also they're subject to being voted out if the citizens don't like them. So they have maybe a different, you know, perspective than the planning commission that can result in some different you know, ways of adoption. So yeah, it's not for issues like this, short-term rentals, it's not at all uncommon. And again, for most issues, the planning commission, whatever they say just goes, but.
One final question.
Mhm.
What should we be considering and what implications might come our way? Because I'm sure you're aware that Garish Township has put together a ordinance that's going to basically eliminate short-term rentals in a few years in Garish. And so once that is eliminated there, you know, I'm concerned about a large influx of people because, wow, there's no other place to go, right? If they want to have a short-term rental on Higgins Lake, which is a huge lake, and Garish Township is the larger of the two, what should we be preparing for and what can you see be the pitfalls that could come to us as a result of that?
Yeah, with short-term rentals, like there's so many factors. I mean, it's like, are there properties up for sale? Are they viable? Are there people actually looking at them? Are families buying them and just living in them? Are they affordable for that kind of thing? Or are they only per, there's almost too many factors to say how, um, Garish's regulations would affect ours. I mean, certainly, I wouldn't be surprised. I mean, just logically speaking, if there's fewer spaces over there
Yeah,
and there's spaces over here, people will come over here. But, if you have a cap, if you have a distance limitation and things like that, you can end up at a point where you hit an equilibrium or where there's just not much more room for people to come in. And so even if Garish is dropping off, but, you may not see, you may see a lot of interest, but you might not see a lot of available property depending on how your ordinance is drafted. And, over in Garish, I don't know. Again, people can just keep doing it as a short-term rental and call their bluff and say, are you going to cite me? Are you going to enforce against me? Or I'm just going to keep doing it anyway. I've certainly seen that a lot. And so, I mean, I wouldn't be surprised if there was more interest maybe if Garish is sunsetting their rules. But, again, depending on how your ordinance is drafted, it may not make much of a difference. That you may already hit, excuse me, your equilibrium here.
thank you so much.
You're welcome. Thank you.
I had one question for you. The licensing fee and the application, there's no set. We can set that price, whatever the board chooses, correct?
Yeah, basically the only caveat is that it has to be that it's going to be set aside in a special fund and it can only be used for like administration, whatever I said earlier, application, administration, enforcement of the ordinance. So, but you can virtually set it at whatever you want. I mean, I wouldn't set it at like 50 grand because I think that there is a reasonableness test.
There's no way to limit them too.
Yeah, there's a test that's
easily.
yeah, there's a test that says you've got to be asking for a fee that is covering your costs and not more. Otherwise, what you're doing is just taxing people and not calling it a tax, and that is illegal. And there have been lawsuits about what is a fee versus a tax. But the line is really, you get to operate in a pretty big bandwidth. Where as long as you can even very broadly justify the cost as being, the fee cost being supported by how much you're going to spend, you're pretty much going to be protected. It's only if you're asking for like 10 times as much as what you would ever need to spend. And like I said, for short-term rentals, on the enforcement side of it, I mean, if you're talking about hiring a full-time short-term rental guy, or enforcement person or a company or something like that, I mean, you're talking about a lot of money
Yeah.
just in that, not to mention the meetings and things. So, if you have 60 multiplied by 5,000, that is whatever that is. I didn't get into law to do math. So, whatever that number is, that could very feasibly be the amount of money you anticipate it costing. And again, you can be a little bit over, you can be a little bit under. You just can't be wildly one way or the other.
Okay. Anybody else for public comment here or questions for Mr. Beal on topic? Well, I can recognize that you got your arm up and you're already on your feet, so have at it. Yeah.
Kidding. I'm Cindy Pop, Lyon Township. Probably you may have already discussed this. April 11th in Birmingham, Michigan, there was a shooting at one of the short-term rentals. So they very quickly, their city council board put a moratorium and stopped short-term rentals because of the uncontrollable element that's renting them and drive-by shootings and what have you. Second of all, I'm concerned when I bought my property, I could have bought, I guess, next to a hotel or a lodge or whatever, and been next to a revolving door of visitors. I chose not to. I bought in a residential area, and now with short-term rentals, that could all be thrown to the wind. And thirdly, I'm one of those people who check for what do you call them? Sex registry people. You can roll up on zip codes and see who's a child molester that's been convicted and where do they live. How do we do that with somebody's checking in and out every week? And I got my grandchildren out there playing. So those are my concerns. You might be able to tell them against it.
Okay.
Mhm. Question.
Again, who's got a comment or question for Mr. Beal on topic for the possibilities of how short-term rental could happen? Come on up. Are you back in country for a while or what?
Couple of things.
State your name for the record.
Jason Phelps, property owner, different properties, but, I'm not really in favor of this short-term rental. And I made a lot of money in the rental business.
If you have a question for him,
Mike.
not the specific,
Comment.
we're not doing comments here as much.
Well, at some point we have. to-
Well, I'll leave it up to you, but I mean, if.
Yeah, no, you can go ahead. No, go ahead and comment. That's fine. Yeah.
Get to the questions.
You made the comment that you're going to win in court, you know, and you have a history of winning in court. I take exception to that because nobody wins in court, really, except the attorneys. To spin in court and dance in court, it's going to cost the township, the taxpayers, at least $50,000-$60,000 a case. And if you're 1%er out here, you know, some of the people on the lake are 1%ers. 50,000-60,000 is nothing to us. You know, it's nothing. It's just going to defer for a few years and allow them to do whatever they want. And I don't consider that a win for the township. Setting up rules that potentially are going to be litigated. And I'm a firm believer of that. And going through the courts just isn't something that we should set ourselves up for. I know you can't control it. You know, anybody can sue, like you said, but by putting in certain classes or certain districts or certain grandfathers or sunsets or, you know, it just probably puts a little target on us. That's my only comment.
Thank you, Jason.
Yeah, and I'll say, I mean, I said I win on that very narrow issue. As far as everything else, you know, it's a shot in the dark. And I mean, I certainly don't disagree. Litigation is expensive. Like I said, if you're going to enforce, you got to be prepared to enforce not only on the paying the zoning administrator guy, but also going into court and paying court fees. You know, they are certainly not cheap. You know, like I said, if you have a cap and you pick 40 losers, that's 40 lawsuits worth of dollars that you got to be spending. So, you know, whatever regulations you're setting up, you got to be prepared to pay the price to enforce them.
Sure, you're closer.
Dan Richardson, Lyon Township, and I'm on the Planning Commission, and thank you for coming. I had a whole long list of questions. You've done a good job, and I don't have but one left. And one quick comment too, Paul, you said the November 24th draft is in flux coming out of the committee, and it's not in flux. That coming out, the STR draft ordinance was completed on November 24th and approved by the Planning Commission as far as that's our recommendation to you.
Yeah,
Not in flux anymore.
well, my reference was we debated whether we should put it on the webpage and decided to put it in the minutes because the township board has not approved that yet.
Right.
So that's what I meant by flux.
Okay, it's in flux, Queen. It's not in flux as far as the Planning Commission is concerned. The only question I would have is that if the board decides to just do nothing on STRs, keep it the way it is right now, where they're not it's not referenced in any ordinance at all, and that means that STRs are illegal here or not allowed, how would the township go about enforcing that? You mentioned something about a citation,
Mhm.
but is there a monetary cost to that, issuing a citation? I mean, can you charge them a $10,000 fee or?
Right. Yes. So the citation would be a zoning ordinance violation citation. So any time that anybody violates any provision of the zoning ordinance, that is a municipal civil infraction. So you'd get a civil infraction citation. So that could be any manner of issues, but one of the most common probably is you're using your land in a way that is not compliant with the zoning ordinance. So, short-term rentals is one example, but like if you open a business on your residential property, a business is not allowed in the property. So you would write them a zoning citation. So what that would entail is the zoning administrator or ordinance enforcement officer or the supervisor, whoever has been authorized to write tickets, would investigate and see, are they actually renting it as a short-term rental? What zoning district are they in? And is it permitted or not? I think the answer we know is it's not permitted, but we want to make sure we know what district they're in. And then you write them a zoning citation. So it looks that there's a citation book that looks a lot like, if a cop pulls you over for speeding and gives you a citation on one of those ticket sheets. We have one for municipal civil infractions. So you'd just put the property owner's name and you'd write the violation of the ordinance and say, you're using your land in a way that's not permitted by the zoning ordinance. Here's the section that governs, there's a section that says if it's not listed, it's not permitted. And then also the R1 district, let's say, is where it's located in. And then you get into court and you're just in front of the judge and saying, so you write the citation, you file it with the court sets a hearing date. I believe in this court, they do informal hearings where no attorneys are even allowed to appear. So it would just be the zoning administrator and the defendant if they choose to show up. And a magistrate or a judge would rule on the case. And then if they want to have a second hearing, then the attorneys are required to show up. But, basically the zoning administrator would say, look, let me lay out our ordinance for us. It's not permitted in the R1 district as a short-term rental. The ordinance says if it's not listed, it's not permitted. And so this person's in violation. They're using their land in violation of the zoning ordinance, and the judge would issue in theory, if we win, if the judge agrees with our evidence, they would issue what we would have them do is issue a compliance order, and then they'd also issue fines. So the maximum fine under state law that we are allowed to charge for any single municipal civil infraction ticket is $500. And that was set in 1970 or whatever. So obviously wildly out of date for pretty much any violation, but short-term rentals, I mean, what a laugh. Like that guy said, they
It's $10,000.
if he gets $10,000 to pay $500 citation, it's like you're considering that a permit fee. That's not a citation. And so the real kicker is the compliance order. Now we can also ask for attorney's fees, and I've had some luck in this court with you can recover your attorney's fees, agency costs. You can get them up to like $1,000, maybe $1,500 in total charges, which again is still not very much. But the key is the compliance order, which would say, you are enjoined, you're banned by the court from engaging in this activity. And if they engage in the activity again, the benefit now that we would have a court order in place is now they're not violating our ordinance, they're violating the judge's court order, and judges absolutely hate that. And judges have the power of civil and criminal contempt, which is infinite. So he could charge the guy $200,000 a week. He could throw the person in jail if he wanted to on criminal contempt for violating the court order. So that's where the real enforcement mechanism comes from. But basically, to answer your question in a long story short, you write a municipal civil infraction citation for using land in violation of the zoning ordinance, and then we'd end up in district court.
Okay, thank you.
Yes.
Andy, come on up, Mr. Burner. So we have a fee schedule, fining fee schedule. Did you mean so $500 and was that year incident wise?
Per occurrence. So if you write them 5 tickets, they would pay $500 per ticket.
So you could in theory give them a ticket every day they're doing
Yeah,
it?
so in your zoning ordinance, it probably says every day constitutes a separate violation. So
I've seen that.
you could write them a ticket every single day. I mean, typically we just do the one and then get the injunction. Sometimes the courts get a little pissy with us if we start to pile tickets into their office, but, yeah, you can write them a citation every single day that they're violating it.
Okay.
All right, sorry about that. Go ahead.
Thanks, Mr.
Yeah, John Bogdan, Lyon Township. Welcome to our fair community, Mr. Bila. We've heard your name quite a few times. I think most of us feel fairly familiar with you, Mr. Bertrand brings your name up often. Question, which relates to Dan's. There is overwhelming opposition to allowing STRs, any in our community. But the zoning aspect of enforcing that seems especially onerous. Is it possible to, let's say, amend the zoning to say, yeah, okay, we're gonna allow a STR, create a police power ordinance, and then say, look, we're gonna limit these down to 0 or 1, because there is such overwhelming opposition. But now we can administer it via a police power, so we don't have to go to court. Or, I mean, if you find someone who's actually operating an STR, then we have some ways of dealing with them with the police ordinance, for instance. You know, if someone is operating STR without a license, you know, it's much more than $500. It's $1,500. It's, I don't know, something that's commensurate with that. Is that possible?
So, yeah, so for any kind of municipal civil infraction citation we issue, the maximum is $500 fine. It's across the board. It's, call your legislator, tell them it's insane. I think it's insane. It's a joke at this point. But, the problem is that no matter what, if you're trying to curtail them or limit them, you're gonna get yourself into court in one way or another. I mean, not as an inevitability, but again, if you're saying, okay, we're going to only allow 5 short-term rentals in the whole township, as Paul said, there's at least like 50. So you got 45 people now who are mad at you, and they're going to be asking, how are you choosing the 5 that you're going to permit? And they're going to fight us over how we choose those 5 that we allow. And again, the 45 people who lose, they're standing to lose potentially quite a lot of money. So they may, sue you and bring you into court on losing money. And, I'll also say, I don't personally relish in lawsuits. They waste a lot of my time, if I'm honest. I have a lot of other work I prefer to be doing than being in lawsuits all the time. I try to keep the townships out of litigation as much as I can, or at least give you a fair warning of when I think something's coming. But Lyon Township, like every other township in the state, basically, you do have legal insurance. So if a case falls under your insurance policy, it may be covered by insurance, and then you actually don't pay anything when you get sued. The legal fees are all covered by insurance. So it's not like a total wash. And again, I don't like to be involved in litigation, and I don't like to spend the township's money because I have plenty of work as it is. So I don't need to get it all out of Lyon Township. But it's no matter what, you're gonna be kind of in an expensive place.
Do you see many townships who are just not allowing any STRs?
Oh yeah, sure. Yeah, a lot of them just total prohibition. And then the question is, how are we going to deal with the ones that exist now that are floating out there? And that question then comes to your court system. Like I said, I think your Roscommon County courts, at least the last time I was here, which at this point is a couple months ago, but I'm sure you had the same judge, was very reasonable. And if you have a court that's familiar with municipal civil infractions, they're familiar with zoning, you can breeze through a case and, do it for like less than $1,000 a case, as far as like court fees, and maybe potentially recover most of those against the offender. But if you have a court system that's more dragging their feet, or if the court if it takes more time to explain to the court what you're talking about, those can get more expensive. So it's like, even if you're talking about a total prohibition, then the next question is, well, how are we going to enforce against the ones that are there now, if at all? And again, we have discretion not to enforce. And so we could just choose to say the township doesn't think it's worth the taxpayers' time, and we're just going to let short-term rentals go. And, property owners will have to deal with, if you're in an HOA, you may have restrictions on it that you can sue privately, or, you may just have to kind of deal with it.
Okay, thank you.
Well, thank you.
Thanks, John. I might be incorrect. in this, but, on the actual numbers. So Garish passed a, short-term rental ordinance where I'm not sure, I think it was pushing 200 that they thought they had. And I could be wrong there. But I always try and watch what they do and see what the pushback is. So they passed one where I believe at the first of the year, they're going to drop that to 80. And certainly probably a more affluent township than us. And I'm curious as to what is going to happen in regards to that, because their long-term plan in 3 years is to sunset them all and have nothing. It'll be, if I live that long, it'll be interesting to see how that all works out in the end.
Yeah, and I mean,
I believe the attorney, apparently that's what they're gonna do. I think your advice is a little more in-depth. Thank you.
yeah, I think didn't you used to have the same attorney as them?
That was,
No.
no, we had Fire Schultz and they have Scott Hess.
Oh, right. Okay, yeah. So, yeah, I mean, I think he's a good attorney. And again, I don't set the policy. And so if the board instructs me to take a path, even if I think it is, like practically unwise, as long as it's legal, I'm not going to say no. I'll tell you the risks and everything, but ultimately you guys decide policy. And I'm sure it's the same in Garish Township. If you guys want to take a certain avenue, I'll tell you the risks and the operations, chance of success, things like that. But ultimately, it's up to you as the board, what you want to do with these things.
What's your legal opinion on that?
What do you mean?
And what they're doing?
Oh, well, I don't know. I'm not, I mean, I'm familiar with Garish just in the sense of,
Please. The police powers that they're using.
yeah, I don't know. The problem is, I don't know how Garish was set up. Like, what was it allowed under their zoning ordinance before? Or
I don't know. All I know is that the current board
That's-
is moving them in that
I
direction.
mean, yeah, what I would say, not knowing much about the scenario, what I would say is, like I said earlier, if you're picking winners and losers, if you have 200 and you're dropping to 80, you're going to have 120 people who are upset. And, maybe of them just suck it in, but that still leaves 20 people who are upset and not willing to just give in. And over the course of 3 years, you're going to have all that. So, not to say that I have no clue. I haven't looked at it in enough detail to say whether what they're doing is lawful or not. But certainly, again, in any scenario where you're putting yourself in between people and a lucrative amount of money, they're going to be upset and maybe bring you to court or whatever else.
Okay, is there any more public comments? Come on, Bruce, you're closer.
Bruce again, Lyon Township. So I just have one quick question. So if you're issuing a citation, who would get the citation? Is it the people that are actually violating it, or is it the owner? Let's say they live in Texas and they have their B&B here. So who would have that responsibility?
So in your zoning ordinance, and if it's written like every other zoning ordinance in the state, it will say you can cite the owner or the operator. So it would be, you would either cite the property owner, which again could be somebody in who knows where, which you just mail them a citation. You don't actually have to fly down to Texas, or the operator. So if it's like being run by some local company or something, or you can even cite the occupant. So you could go in there and hand the citation to the person who's there right now. But I mean, with a short-term rental, that's like worthless because they're some person from out of, they're from downstate or Chicago or whatever, and they have no idea what the rules are. They just pick the thing up on Airbnb. So you would cite the owner or the operator. And I've had, if you cite the owner in Texas and they don't respond, I mean, that's a dream case because that's just a default. So we just get everything we want from the judge, no questions asked. We get the injunctive order, and then, like I said, once the judge's court order is in place, that's a much more powerful enforcement mechanism, and he can order really high civil fines. He can order them to be jailed and extradited from Texas to Michigan to be thrown in jail. I don't know that he would do that, but he could certainly charge them a lot of money that would end up on their tax rolls, and then the property could be foreclosed on,
Thank
something
you.
like that. Yeah, thank you.
Thanks, Bruce. Who's next?
Yeah.
All you gotta do is raise it again and you're next. Okay,
All right.
short of wrestling with each other to try and get up.
Had his hand up several times, so I was going to let him go first. Mary Jane Dolan, licensed Lyon Township. I have a couple of questions. There's been discussion of pending statewide legislation. If there is a short-term rental ordinance at the township level that's in place prior to the statewide legislation, and it's stricter than the statewide legislation, would it remain in place or would it get modified? That's a pretty broad question, I know.
No, yeah, no. So, it depends on what's said in the legislation. But almost 100% of the time, the legislation says this takes effect immediately and overrides anything that you have that is in violation of this. So if, for example, the one piece of legislation that I know is pending, the only thing I can remember about it is that it says it must be allowed in any district that allows for a single family residential dwelling. So if we said they are not allowed in R1, but our R1 allows for a single family residential dwelling, our ordinance would be, that provision at least would be kicked off and we would have to contemplate it under the single family dwelling. And typically with the legislation, they would give us time, it would take, they would say it takes effect in 6 months or something. So I would certainly, if something like that was passed, I'd reach out to all my clients, including Lyon Township, and say, hey, this thing's been passed. We got to update our ordinance to align with the state law. But yeah, the state law would control whatever their rules said would control what it would regulate us. We wouldn't be able to be more strict. And what I've seen from the state law is they're trying to open the doors and let more people in. And so we wouldn't be able to restrict more than what they did if it passes. And so if you like local control or if you don't want it to pass, you can call your legislator, tell them about it. Whether they listen, who knows? But
Yep.
okay, you have some other questions though?
Yep, a second question I had is, and I have no idea what I'm talking about with this one, but if we think of short-term rentals as businesses and we did something to allow them within the township, would the tax basis for that stay as a residential property, or would it be considered?
So yeah, so that's more of an assessing issue, and so the township board doesn't get to just like decide how properties are assessed. That's up to your tax assessor, and I believe in the most recent, the state of Michigan puts out like assessing guides and tells assessors how to calculate value and stuff. And I believe in the most recent one, if I'm not mistaken, either the most recent one doesn't say anything about short-term rentals, or it says to just keep treating them as residential use unless it's a certain number of hours or something. So it could potentially change how it's assessed, and it could certainly change the tax value of it. I think a lot of times properties are already so expensive these days that whether it's commercial, whether it can be rented out or not is like, doesn't make that much of a difference. But certainly if it's assessed as commercial, you could be talking about an increase in the taxable value as opposed to just purely residential, because there's a lot more opportunity to make money. If a property can generate a mountain of money, that's one of the elements that they look at for its assessed value.
Right.
So it could be, but it's a question for the assessor, and also like how the state of Michigan guidance comes out. I'm sure they're working on it now for short-term rentals because they're everywhere.
Okay.
So I'm not sure how they would come out on it.
All right. And thinking my question, it certainly wouldn't count for the homestead exemption then, right? If it's being used as a.
Yeah, so it would be like if it was going to be counted as a PRE, like a principal residence exemption or something, they have to meet certain, and I don't know the requirements off the top of my head, but yeah, if they're renting it out half the time and the PRE says you have to live there full time, then clearly they're not doing that. So yeah, then in that case, they wouldn't get the PRE exemption and they would be taxed like normal.
Okay. And then I think this is my last question
Mhm.
is, have either the township's board's proposal or the planning commission's proposed ordinances been reviewed for any potential wording, legal issues within the wording that's within either of them?
We've gone back and forth so much. I know at some point, I think I have read over all of them. And I must have seen the planning commission one at some point. I certainly saw the township board's initial proposal. And like I said up top, at the moment, there's no state preemption legislation. So a lot of the regulations are just, at the pleasure of the board almost. And, what I said earlier, and it still holds true, is that any regulation that you write, you just have to be prepared to enforce and think about how you're going to enforce it and who's going to pay for it. So I think in whatever I reviewed, I'd probably like to review it again, I suppose, just to be sure if you're, before your next meeting. Well, your next meeting's tomorrow.
It has been a year. There are so many things that are different in understanding now from when we wrote that.
Yeah, so there could be, but I certainly do. I mean, Paul, we're in touch all the time, so certainly he keeps me informed of what's going on at the township. And if there was any legal problem with the ordinance, I would have it removed. But most of the time, it's not so much a legal question as just a practical. Are we willing to enforce what's in there? So I don't believe the current ones have anything like outright unlawful. It's just a matter of, the policy of the board and how restrictive and et cetera, et cetera.
Great, thank you.
Thank you.
Thank you. Who's next?
You could be the last one now.
Going once? Well, you gotta raise your hand
Yeah.
and then I say, come on up. Okay, come on up. Otherwise, I don't know what you're doing. Well, I didn't call on you, so we got to you now. Sorry about the delay.
Thank you very much. First of all, I very much appreciate the information that you're providing to us. And excuse me, you hear me?
Oh, yeah, your name.
Philip Robinson.
That's better.
Anyways, I do appreciate all the information that you're providing. I think it's been very helpful. And frankly, I've been impressed by your ability to kind of draw these things together across all these different cross questions. You have been often quoted, or at least characterized in terms of your input to ordinances over time here. And so a lot of my concerns about this have to do with compliance and money. A thought occurred to me, and maybe you can give me your legal view on this. Since we have a population of people who seem to be interested to do this, is there any way to create a group where they would, at the same time they're enjoying the benefits of the community, giving them access to do this, that they share in the liability that may occur with respect to legal costs and personnel costs, so that it's not just a fixed number that we have to guess on how many lawsuits we're going to get, but we could actually make them a partner in sharing the cost of doing that. So that's basically one question right there. I just wonder, I don't know what the legal liability insurance limit is that we have, but there must be a cap on how much this insurance policy is willing to pay. And I have no idea, nobody's mentioned that number. That would be good for.
Well, and with the insurance, if you've ever looked at an insurance policy, even my car insurance policy is like 5,000 pages. It's like, even like my car insurance policy is like 5,000 pages. So I know the township's insurance policy is a mountain long, but I've seen all types. I've seen some insurance companies that will say, we will cover an unlimited number of claims in a given year, and each one up to $100,000.
And what do we have here?
I have no clue. You'd have to ask your insurance provider.
I don't know what that is.
I know you have it, but I don't know what it is.
Yeah, for example, for open meeting act violations, it was 20,000. I don't know what it is.
Yeah, so it would be like, this one would be, I don't even know. I would certainly talk to your insurance agent and discuss
I
this.
think it's a useful question because we're
Yeah.
talking about.
Oh, certainly. Yeah.
Talking about lawsuits, or it sounds to me like there's about 1,000 ways to get sued, whether you do something, you don't do it.
Yeah, unfortunately.
Something in between, you deny a permit, you allow a permit. And you made a comment earlier, when you were giving your presentation about, enforcement and the ability of the township to enforce or not to enforce things. I'm assuming this does not exclude the possibility of uniformity in how that's applied. Is that correct?
Yeah, so
Can you do it selectively? And so you can say, okay, well, we're going to go ahead and we're going to give you a citation for burning leaves, but you over there, you're okay. Is that-
Yeah, so there's, when you get high enough up in the legal theoretical world, you run into equal protection violations, but it's a long walk to get there. And along the way, the township is permitted to consider like dozens of different factors in terms of whether or not to enforce that have nothing to do with equal protection. So, the one example that I give a lot of the time is up in the UP where I have a client, we had two big like blight junk problems where there were a ton of garbage and stuff all over the properties. And one of them was on the main drag coming into town, right when you get to the downtown, right in front of everybody where you can see. And the other one was way off down a dirt road. And so the township, they were the same violation, but the township said, well, we're going to enforce against, we only have enough budget to enforce against one. We're going to do the one on the main drag because it's on the main road coming into town. Everybody sees it. It's unsightly. It makes our town look like a dump. So we're going to enforce against that person and not this person because of the location of it. So that's just one, example of a perfectly legitimate reason why you would choose to enforce against one person and not another.
Even that is subjective, though.
Very much so.
It might be somebody else's paradise.
Oh yeah. Oh yeah. Well, yeah, of course. And now a lot of people tell me that their blight is their homestead or whatever. And I'm like, it looks like a bunch of rotting trash to me. But, the other thing of enforcement is like the viability of a case. So if we get two different complaints on two different properties and I look at the complaints or the zoning administrator looks, and like we said, one of them is rented out every week. It's on Airbnb and it's a big frat party. And the other one was rented one time to a guy's family member for 1 week. We might look at those two cases and say, we may well lose this one, but this one is an easy case. We'll take this one. Again, that's another perfectly legitimate way to select which cases you want to enforce, or again, you can choose not to enforce at all and just say, we just don't have it in the budget, or it's just not in the public interest to enforce. And there's no way that residents can force you to enforce your ordinances, I guess is the thrust of that.
Okay, now with respect, we're focusing specifically on short-term rentals
Yeah.
here. And according to this definition, it's 30 days or less or something like that.
Well, whatever's written in the ordinance, I said, typically, you're never going to talk about a rental longer than 30 days because that's just a month-to-month lease, and that's
Okay, so if someone had a home here, they would be able to lease that for what, 6 months or a year without having to even think about consulting anybody or looking at the zoning?
yeah, well, because that's pretty much just a straight up residential use at that point, to lease out a property for, if you have a year to year lease, probably half the state lives on a leased property, not property that they own.
For 30 days, you're in a whole different,
Yeah, now you're just talking about a month-to-month lease, which is, I think, a court. I don't know if there's been a case about it specifically for 30 days, but they say like, look, if you're renting it, a lot of people live on a month-to-month lease and they rent a property, they pay their rent, they get to stay there for the next month, they pay their rent, they stay there for the next month. So, that is just residential use. And also in some definitions, you talk about the transient nature of it, where if you're paying for 30 days or more and you're on this month-to-month lease, you're not running into the problem that a short-term rental sees, which is constant like rollover of people. If you have one person coming in every 30 days, it kind of sounds like maybe you're just a bad landlord as opposed to a short-term rental operator.
related to this short-term rental and the compliance aspect of it, which seems to be a big topic that we're talking about here. It seems to me that the problems can start right from the get-go beyond the ordinance when the permit is applied for and approved and evaluated. And so it seems to be there's a lot of places along the way where this thing can become a problem. And so what credentials, are there any legal credentials that a compliance person must have in order to be able to administer this program?
No. So there's no zoning administrator. Your zoning ordinance will define who the zoning administrator is and what like job qualities or job, what's the word, qualifications they should have, but there's no legal, they don't have to be like a certified police officer and they don't have to carry a badge and a gun.
Report to the board or they report to, who do they?
They'd report. So the board is responsible ultimately for hiring and firing employees. So they'd report to the board, but the board could also set, like they could say the supervisor is going to be that guy's point of contact as a manager, and if there's any problems. I know, I was talking to Pun, he said, I don't have enough work to do around here. I'm wondering if you guys can add more
So
stuff.
currently, is it in our building inspector?
We had
Is the zoning?
building is also our zoning.
Yeah.
Yeah, so for building and plumbing and mechanical, electrical inspections, there's you need certain licenses and stuff, I
Yes.
believe. But for zoning, you can be anybody.
Never like, so I mean, there's a program here and like other services that the township has, is it possible to subcontract this to an outside
Oh, very,
organization
very much so, yeah.
and then relieve these gentlemen of all the burdens and having all these little sessions here and there? I mean, at some point they'll have to interact, but the compliance part of it, are there companies that do this in your experience?
Yes, so there's a couple avenues. So in quite a few townships I've had, like I said, they will hire a short-term rental management person solely for that purpose. And sometimes it's a firm. So you hire like a
Yeah.
planning firm or a consulting firm, that kind of thing. Or there's,
To avoid attorney clients.
yeah, and it's a group that is more familiar with what's going on zoning enforcement wise and familiar with how to write citations and how to review things. So there are, like, what's the name of it? There's one called like Michigan Township Services, like Safe Built will do, I believe they do zoning enforcement as well. There's zoning services of Northern Michigan, something, I don't know. There's a bunch of companies that do it. Up North Zoning, that's another one that I know, these are all like companies where they contract with many different townships to do whatever they want.
Help you budget for what you charge the.
Yeah, so they could say, typically the company would say, okay, you're gonna pay us like $5,000 a year to be your company, and that will cover these things. And then in addition to that, every zoning permit, if you come in to get a zoning permit for a shed, you're gonna pay $100. 50 of that will go to them and 50 will go back to the town.
And when somebody's having a loud party, they're gonna show up and just write them up for their violation.
Yeah, so they could, if that was part of, now, again, you'd have to pay them to do that. Obviously, they're not gonna just show up for nothing,
How
but,
far is the nearest one from here?
I would have no clue. I mean, there's probably one in
I'm gonna
Houghton Lake or
I
Russ.
think you have a viable idea. I think if you could pursue that and get the information to us on who's around and what they can offer, that would be helpful.
Well, I don't want to step in your territory there too much, but I just.
I'm just saying that-
Contacts, whether you've seen this.
Yeah, most certainly, yeah.
Part of the problem here is you farm out the compliance thing and say, well, if they're making too much noise, call the sheriff's department. Okay, well, on the 4th of July, lots of luck.
Oh, yeah. Exactly.
We have, non-compliance in practicality if we don't have any way to enforce it.
Exactly. No, yeah, exactly right.
This is part of the complexities of ordinances in small townships.
Yeah.
And we're like assessed at 180 compared to some of these townships, which involve big municipalities and whatnot.
Yeah, but 180 is not bad though. I fly 152, so
So
that's,
are we over our skis in terms of trying to be able to manage this internally?
no, I don't think so. I mean, it's complicated. Yeah, look, Paul's a professional.
Well, no, I mean,
But
I get where you're going, Phil, but let's keep it on the legal aspects of short-term rental blended.
Well, is that legal? Is it legal to hire a subcontractor? That was,
Yeah, you answer.
yeah, certainly it is.
yeah, well, that's good. I appreciate your answer. Yeah. So anyways, thank you very much. I hope we have enough insurance. I hope we have, consistent compliance, officers that will be following us up and that everybody knows what their job is and they can get it all done. So it'll be an interesting experience. And the only other question I have for you, getting back to this legislature, thinking about the
Keep it right on topic, Phil.
Pardon me?
Please keep it right on topic, and I will cut you.
I'm following up on what the attorney said.
Okay, you're gonna stop at some point.
We have legislation that's pending in the state legislature, right?
Mhm.
So are we premature to go through all this and then, they're gonna go ahead and jerk the rug out from underneath us next year?
No, so the legislation has been, I mean, it's been floundering a little bit. It's out there, but it's been flopping around, and it is, the only thing I've seen proposed is not complete preemption. It just says any regulations you do have to meet these 3 or 4 standards. And so other than that, the legislation has said you can regulate all these other things. You just can't, for example, prohibit it in the R1, single family residential district, let's say. So that alone is not enough to say, well, we just shouldn't do any of it. It's still worthwhile to prepare. And again, this legislation, it's been floating around in various forms for like 2 or 3 years now. And there's nothing to say it won't be for another 2 or 3 years, and it may die. And then in which case, you would have rather started earlier than later on regulations. So, and every version of it I've seen has not been total preemption. So there's still going to be some area for township involvement.
Thank you very much.
Thank you.
Thank you, sir. Anybody else yet? Today, this day. Mr. Bedoya, where's those NASCAR hats?
Sam Bedoya, Junior, Lyon Township. The police power penalties versus the draft of the STR penalties. I would like to pass on, or maybe you all have looked and compared both to see which way might be better, or maybe try and blend them in as you've talked about. When you had mentioned earlier about let's say it's zoning, and each person that applies has to go through the planning commission format of some kind,
Yeah, if it was through like a zoning special land
Right.
use permit. Yeah.
special and yes. So that would be like, it could be several at one time, or is it, let's say they submit several of them. What's the format? What is the planning commission use as a format to review, suggest, et cetera?
So it would be, so the planning commission already handles special land use permits for all kinds of other uses that are not short-term rentals. And it would be the same process where essentially your special land use permit, your zoning ordinance would say, these are the things that have to be included in an application. And then a person would submit that to the zoning administrator. The zoning administrator would look it over, make sure it's complete, make sure they've submitted everything they're supposed to. And then it would go before a public hearing at the planning commission, and the planning commissioners would look over what's in the zoning ordinance, what are the regulations, and what is the person submitted, and do they match? And if they match, then you grant the special land use permit, or like I said, it may come to the township.
Now I can understand that.
Well, let me add something here that 2 of the 3 scenarios do not include that the zoning of the regulations, only that it is allowed
Mhm.
through zoning. So if it's police power and only allowed through zoning, planning commission's not going to be sitting there making all those decisions. They would already be in the police power.
Mhm.
I understand that
Yeah.
part. I do.
Yeah.
I understand that. We have always looked at the term local agent to be local contact. I know you had mentioned it as local agent.
Yeah.
Is it, now do we need to change that?
No, it's the same thing, just a local, really the definition would just be somebody who can get from wherever they are to the site in less than, like, typically I say like 45 minutes. So that can be, I've seen some companies that do it where they just have a guy sitting in some room somewhere all the time waiting for a phone call. Or it can be if you live nearby or if you have a family member or whatever. So yeah, it's the same concept though.
Okay, one last question. Bring me up to speed on this. Anything that a township has as an ordinance, the police department cannot enforce.
Yeah, so I guess I should say when we talk about like a police power ordinance, that does not mean that we need a police officer to enforce it. So we don't need somebody with a badge and a gun to go and enforce a police power. That's just a legal term of art. And we can enforce that, Paul can write tickets, or our zoning administrator or ordinance officer can write tickets under the police power. So the police departments will only typically enforce our ordinances if we contract with them. So if we have a contract with a deputy sheriff where they will come and patrol around our township, then in there we would say also, by the way, will you write citations under our ordinance? But otherwise, they're only writing state law stuff.
You answered when you said contract. I didn't know that.
Well, I can add to that because I've been down this road. Maybe you heard when we did this before. They cannot enforce our ordinance. I checked into entering into an agreement with the Roscommon County Sheriff's Department about their involvement in being able to write tickets for burning and noise problems. That turned into, when you get all the input together, it was kind of decided, we're not going to turn the police loose in this township. On the other hand, I said, you should be able to call them and they can write a ticket for disturbance of the peace. In fact, Steve brought that up. Sheriff said, there's no such thing. There is no like disturbance of the peace ticket. Third part of this, a resident called me and said they had a short-term rental near them. It was too loud 2 nights in a row. And this is after I put on our webpage, call the police if you feel threatened or if you have trespassing problems. Called the police and I had talked to the police and they did show up, according to her. And shut it down one night and shut it down the next night. But I don't know that they ever wrote tickets. I said, you got a police report? Yes. Please give it to me because we can use this on that short-term rental. Never heard from her again. So what part of that might have been lies, I don't know. But the police, unless we enter into an agreement with them, cannot write tickets for our ordinances. But if you got a problem and they're not doing something else, they should show up. I agree with everyone. I don't think there was. Sheriff told me there's no such thing. Maybe you know, there's no such thing as a disturbance of the peace ticket.
Learn something.
Yeah, I thought there was a general one, but maybe every time they've written it, it's under our own, like under a county or something.
Well, I thought it was, I said, does the county have? No, can you use a state? State doesn't have one either.
Huh.
So it must be some other version that they're,
Yeah, something else they're pulling from. I don't
you
know.
know, drunken disorderly. I don't know.
Thanks for your time.
Yeah, well, thank you.
We covered everybody but you.
You've had enough of the fun.
Okay, anything left from, well, we're gonna leave the public comment as the last comment, so. Thank you, Mr. Beal.
My pleasure.
Always informative.
Yes, thank you.
And at that, I would accept the motion that we adjourn this meeting. Somebody wants to make it?
I'll make the motion.
I'll second it. Any further discussion?
No, sir.
Okay, then, I'm going to declare that the motion is accepted and the meeting is adjourned at
1:23.
okay.
I'm sure Mr. Bill will check into that in a hurry.